Aloha mai kako, and thank you so much for joining us this evening. My name is Troy Andrade, and I'm a law professor and director of the Ulu Lehua Scholars Program at the William S. Richardson School of Law. I'm also fortunate and honored to serve as a member of the executive board of the King Kamehameha V Judiciary History Center. On behalf of the Judiciary History Center and the Ulu Lehua Scholars Program, it is my distinct pleasure to welcome you to this special event titled 100 Years of the Hawaiian Homes Commission Act: Legacy, Opportunities, Challenges. While the remarks shared today don't necessarily represent opinions of the judiciary, it's important to recognize Chief Justice Mark Rechtenwald, the Hawaii State Judiciary, and the state legislature for their continued support of the History Center's mission, which really provides a venue for this discussion and the many wonderful programs that the History Center puts together. Tonight, I'd like to send a special thank you to Brianna Govea, the program specialist with the History Center, for her tireless work on this program. Tonight, you're in for a real treat, as you will be learning from experts about an often misunderstood and I think devalued law. Next week, Friday, marks exactly 100 years since the passage of the Hawaiian Homes Commission Act, a law that then delegate. Yes. Okay, thank you. Here we go. Zoom for you. Let me try that again. Next week, Friday, marks exactly 100 years since the passage of the Hawaiian Homes Commission Act, a law that then Delegate and Prince Jonah Kuhio Kalanianaole and Territorial Senator John Wise proposed to rehabilitate a dilapidating population of Kanaka Maoli. Has the Hawaiian Homes Commission Act done what it was intended to do? What are the challenges in implementing the intent of the law? And what are the opportunities that lay ahead? These are just a few of the areas that our speakers will be addressing tonight. Tonight's program, in more ways than you know, is very, very important to Kanaka Maoli. 2 days ago, after years of helping my 61-year-old dad jump through bureaucratic hoops, my dad received confirmation that he was placed on the waiting list for Hawaiian homestead lease. Will he ever get a lease? Can my dad hand his spot on the waiting list to one of his children? What if my children don't have the requisite blood quantum? What happens? While today's program will not discuss my dad's situation in particular, you'll be given the tools to begin to understand this really nuanced and complex area of law. So I encourage all of our audience members to send in questions using the Q&A function at the bottom of your webinar screens, and our panelists will answer them as many as they can at the end of the program. Another friendly reminder that this webinar is being recorded and will be posted on the Judiciary History Center's YouTube channel for your future enjoyment. It's now my privilege to turn the virtual microphone over to the Executive Director of the Native Hawaiian Legal Corporation, Sylva, and her colleagues, and our esteemed panelists, David Kauila Kopper, Ashley Obrey, and Henderson Huihui. I'll let them introduce themselves, but thank you all so much for being here tonight. Summer, take it away.
Mahalo so much for such a warm welcome, Professor Andrade. And aloha to everybody for joining us. Special thanks to the Judiciary History Center, the Ulu Lehua Scholars Program, and from all of us here at the Native Hawaiian Legal Corporation. Mahalo for sharing your Pauhana Hour with us for this important discussion. As Professor Andrade stated, I'm Summer Sylva, NHLC's Executive Director, and I'm joined here today by 3 of our staff attorneys, which include our Director of Litigation, Kauila Kopper, our Legal Practice Administrator, Ashley Obrey, and an Equal Just Works Fellow, Henderson Huihui. Before I introduce them, I just wanted to start by giving you some background on the Hawaiian Homes Commission Act. July 9th will mark the 100th anniversary of the Hawaiian Homes Commission Act, the law that created a homesteading program that administers residential, agricultural, and pastoral leases to Native Hawaiians who satisfy a 50% blood quantum requirement, and whose ancestral ties date back to the natives who inhabited the Hawaiian Islands prior to 1778. We've long understood that the purpose of this act was and continues to be to rehabilitate Native Hawaiian beneficiaries by returning them to the land. You can go to slide 2, please. The champion of this act, Prince Jonah Kuhio Kalanianaole, took to the floor of the US Congress in 1921 to urge its passage, and then implored lawmakers, and I quote, "The Hawaiian race is passing, and if conditions continue to exist as they do today, this splendid race of people, my people, will pass from the face of the earth," end quote. The legislation proposed seeks to place the Hawaiians back on the soil, and all really to ensure that the people and their way of life would be preserved to posterity, right? So what did the act aim to redress or rehabilitate Hawaiians from? Well, principally, it was to redress the mass dispossession of lands endured by Native Hawaiians, first by the Great Mahele Land Division in 1848, which gave rise to private land ownership. And then as a consequence of the 1893 overthrow and subsequent annexation, through which 1.8 million acres of former government and crown lands were confiscated and transferred to the US. The act also sought to stave off and reverse a tide of declining population numbers, the consequence of disease introduced by Western contact, and other dismal socioeconomic indicators related to health, educational opportunities, economic opportunities, and political representation. In sum, the act was enacted to return Hawaiians to the land and to provide them financial support to assist with and improve conditions that were undisputably lacking for a Native population that had been grossly underserved and marginalized. So too, the act supported a measure of self-sufficiency for Native Hawaiians and the self-determination of Native Hawaiians in the administration of this act, in order to preserve for them their values, their traditions, and their culture. This important self-sufficiency and self-determination aspect is a commitment and purpose of the act, particularly relevant and consequential today. And we'll be discussing that in more detail later, but please do keep that at the forefront of your minds, because they are goals and purposes as vital as those returning Native Hawaiians to the land. Speaking of land, what lands were being returned to these qualified Native Hawaiian beneficiaries to achieve these really lofty goals? Well, some 200,000 acres of the confiscated 1.8 million of government and crown lands transferred to the US were allocated to this program. But as the next slide illustrates, the vast majority of those lands, over 60%, were either completely unusable or unsuitable for residential, agricultural, or pastoral purposes. Basically, they're a mix of conservation and special district lands, as well as what are called general ag lands, which by definition are so remote and so costly to bring in infrastructure to. And infrastructure is a cost that DHHL cites as their biggest barrier to developing more leaseholds, right? So that kind of land at best would require 20 plus years to make them suitable for homesteading, or part of the corpus provided for under this program. To help illustrate, what this unusable and uninhabitable, point is if you've ever driven along the Makapu coastline while you're entering Waimanalo, which is where I live, those steep cliffs that you see, Mauka constitute 1,400 of the 200,000 acres that were set aside for homesteading. So what does this tell us? Well, on the one hand, it reveals the really dark underbelly forces, honestly, mainly powerful sugar growers and ranchers that sought to blunt the act's impact from the outset, afraid that this program would disrupt the status quo that had been serving their interests really well. Mainly their leasing of large tracts of our most valuable public lands for private profit and personal gain. But on the other hand, it also provides some historical and contemporary insight important to our sense of justice ethic into why the leasing out of valuable Hawaiian homelands to non-Hawaiians, or the uncompensated use of these lands by state and federal agencies, or the ongoing failure to adequately fund the Department of Hawaiian Homelands, which currently administers the trust with the oversight of the Hawaiian Homes Commission, is really so disquieting to Native Hawaiians and their advocates. If there's so little usable land allocated to this program to begin with, and so few who can satisfy this 50% blood quantum requirement then and now, why are the over 28,000 waitlist beneficiaries not the state's most pressing priority 100 years into this program, and less than 10,000 leaseholds awarded to date since the program began? The waitlist in 2021 alone is 3 times the amount of leases awarded over the last 100 years total. Per DHHL's stats, 6,000 lots were developed in the first 75 years of the program, 4,000 in the last 25 years. The conditions and circumstances of Native Hawaiians that Prince Kuhio lamented way back in 1921, sadly, haven't changed all that much a century later. And that includes having to contend with a small but powerful minority who worry that truly fulfilling the Act's purpose would disrupt the status quo that has been serving their economic interests really well for a really long time. So let's look at 10,000 leasehold awards period. On the one hand is nothing to snuff or take for granted. That means 10,000 families, 3 to 4 generations over, because these leasehold awards are for 99 years, have received housing stability not otherwise available to them. That is by all accounts a win for Native Hawaiians. But we can't ignore the 30,000 or so who have waited, some dying on the wait list, for their opportunity to avail themselves of a program created for their benefit too. Because let's remember that that denial has deprived them and their descendants, 3 to 4 generations worth, housing stability entitled them under the Act as well, and entrusted to the state of Hawaii to fulfill when it was admitted to the US. You know, that's a solemn trust and priority that should be elevated to the highest degree. So yes, today we're going to be discussing the challenges that have hindered successful implementation of the Act. We absolutely need to identify and acknowledge and confront the shortcomings to find solutions. But we're also going to be discussing the opportunities, the low-hanging fruit that could really swing wide open access to justice opportunities for a historically underserved and too often overlooked or sidestepped population. And we're going to ground these discussions this evening focused on the Hawaiian Homes Commission Act's purpose, as articulated in the next slide, to enable Native Hawaiians to return to their lands in order to fully support self-sufficiency and the self-determination of Native Hawaiians in the administration of this Act and the preservation of their values, traditions, and culture. Now that's where legal advocacy comes in. And for the last 47 years, Native Hawaiian Legal Corporation has been dedicated entirely to exclusively addressing these and other legal needs of the Native Hawaiian community. We're really proud to be the only lawyers who every day, every case, every service is dedicated to advocating on behalf of the Native Hawaiian community. Next slide, please. Our organization was born out of a 1970s grassroots movement that sought to combat the systemic dispossession and alienation of Native Hawaiians from their ancestral lands. Indigenous dispossession in the broadest sense is a really effective way to destroy all or part of the culture of a people, their ancestral ties, and their group identity. And so in the face of that reality, that very real and destructive injustice, what started as a volunteer-run referral service evolved into a full-fledged law firm that fought the state or private state-sanctioned conduct to secure rights for Hawaiian homesteaders, water for taro farming, access to shoreline areas for fishing, and to prevent Hawaiians from losing ancestral lands, or at the very least, receiving a fair compensation for them. Since then, through now, our singular mission is to perpetuate through legal and other advocacy the rights, customs, and practices that strengthen Native Hawaiian identity and culture. We provide low-cost legal help and services to approximately 400 individuals annually in practice areas that include quiet title defense, protection of public trust lands, including ceded lands and the Hawaiian Homelands Trust, and protecting the exercise of traditional and customary rights. And we do all of this work as a nonprofit law firm, no small feat for an organization of our size and operating budget, about 5 to 7 attorneys, an equal number of support staff, all of whom serve over 400 individuals in the community each year on cases big and small, on services brief to really protracted litigation that lasts decades. But every case we take on is in service to our mission, a more just Hawaii, guided by Hawaiian values, customs, and ways of knowing, and advocacy, legal and otherwise, that strengthen Native Hawaiian identity and culture. It's why I'm super proud to introduce you to our staff attorneys and frontline advocates to share with you their knowledge, their insights, and their experience advocating for and prioritizing the rights of Native Hawaiian beneficiaries. Ashley Obrey, our legal practice administrator, will begin this discussion by diving deeper into the Act's purpose and how that plays out in the law. In principle, particularly as to the jurisdiction of the Hawaiian Homes Commission, but in practice as well, for those of you eager to learn how your work in advocacy or your own personal understanding or the actions you can take to further the purpose of the Act can be achieved. So Ashley, thank you.
Thank you, Summer. Aloha kako. I'm Ashley Obrey. As Summer did mention, I'm a staff attorney and legal practice administrator here at Native Hawaiian Legal Corporation. I began my work here in 2010 and I've been here about 6 years. So I took a little bit of a break in between, but my work here has sort of run the gamut of our practice areas, but specific to Hawaiian homes, beneficiaries. I've worked on cases trying to get needed infrastructure to homestead areas, assisting beneficiaries in amending birth certificates in order to qualify for homestead leases. Also worked on a case that resulted in the promulgation of rules to allow DNA testing to be submitted as part of an application in order to be qualified to apply. So overall, I'm just very happy to be working for this organization and getting to serve this client base. It's really a privilege to work for Native Hawaiians. So with that said, for those of us who work with clients who have DHHL issues, or you may know someone who is a lessee, or you're just curious about it, we thought it'd be helpful to share some information that reminds us how we can best support and implement the purpose of the Hawaiian Homes Commission Act, but it's also useful on a more practical level when you have to navigate the Act and its rules, and whether you're an attorney, a beneficiary, a community member. As Summer had discussed in detail, the purpose of the Act, when you really boil it down to its essence, is the rehabilitation of Native Hawaiians through housing, justice for Native Hawaiians by putting them back on the land through this homestead program. We can switch to the next slide. As a condition of statehood, we understand that the state has a trust responsibility to faithfully administer the provisions of this Act on behalf of Native Hawaiian beneficiaries. And then with respect to the extent and nature of these trust duties that the state has, which are also stated explicitly in the Act itself and its implementing rules, the Hawaii Supreme Court has explicitly recognized that these are high fiduciary duties that are normally owed by a trustee to its beneficiaries. So because of the purpose of the Act, the trust responsibility on DHHL and the Hawaiian Homes Commission, when it comes to matters surrounding the administration of this program, there really isn't a whole lot that can occur without the approval of the department and the commission. And when you think about it, that makes a lot of sense because they have these fiduciary duties to ensure that the Hawaiian Homelands program is carried out in accordance with the purpose and spirit of the Act. Then in our next slide, I have a kind of a short list of some of the kuleana of the department and the commission. It's not an exhaustive list, but I think it gives a pretty good idea of the breadth of their responsibilities and are worth noting, and all of which just sort of point back to the fact that the commission does have the exclusive authority over the trust and lease management issues. And one of the things that I really wanted to make clear is that the commission's kuleana really is so critical to the success of the program that the Act itself actually precludes the court from assuming jurisdiction over lease-related matters, except in really narrow circumstances. As the next slide shows, there's language in the Act that says that a beneficiary's interests shall not be subject to attachment, levy, or sale upon court process. And it lists just 4 exceptions, which are all narrowly or rarely applied. They're very narrow, and they all have to do with enforcing a guaranteed debt or obligation that had been previously approved of by the department. So all that to say is the department ultimately has the final say, as well as a recognized fiduciary duty to exercise authority when it comes to the administration of the trust, and really to ensure that the Act functions as it was intended. And we think it's really important to understand this on multiple levels. So, for one, as on a practical level, if you're an attorney, you don't want to waste your client's time going to court on issues that are squarely within the jurisdiction of the commission. We have seen that happen recently where our clients, 4 co-lessees, went to court effectively trying to cancel our client's lease using the partition statute, and the court dismissed the case because of a lack of subject matter jurisdiction. So not only does this raise one narrow, small side issue of the fact that naming multiple successors often gives rise to complications among them at a future date, but there's also an important lesson to draw in terms of this legal jurisdictional perspective, that it's really important to always begin with the commission because the commission has these duties. For a lessee, the lesson is important as well. Again, you go to the commission first. If a lessee has an opportunity to appear before the commission at a regularly scheduled commission meeting, or if they're a petitioner at a contested case hearing, it's really important to understand that this opportunity before the commission kind of is your day in court, so to speak. So in terms of advice to a non-lawyer beneficiary, I would say, to use that opportunity to make your best case, to be strategic in what you submit for review by the commission. You may not want to paper the commission with tons of documents that don't necessarily advance your case, but on the same token, you want to make sure everything is everything is out there that's necessary. If you have to, because it's overly complicated, hire an attorney, because even at the commission level, this is your opportunity to be heard. But I think the biggest message that I was hoping to get across by this is that what you're doing by following these processes that are set forth in the Act and set forth in the rule, and not hightailing it to court at an improper time, is really upholding the autonomy of the commission over this trust and promoting self-determination for Native Hawaiians in the context of the Act and this program. And this is something that any one of us, whether an attorney, a contractor, a neighbor, friend, lessee, can do and can understand to promote justice when it comes to the Hawaiian Homes Commission Act. Because when you look at the Act for what it is as a form of self-determination and justice for Native Hawaiians, and this same compelling purpose, right, where we have this determination, self-determination over this trust corpus, this limited land base, adhering to the rules and following the process really allows the commission to do its job as the trustee and to fulfill the purpose of the Act. And coming from us as NHLC, I think we often have to sue to force the commission to uphold these trust responsibilities. And it's important for practicing attorneys and lessees and others in the community to keep in mind that when you're dealing with issues surrounding the trust, when you understand and you can uphold the integrity of the Act, you're really, there's a far reach to that. It has far-reaching effects. And by honoring the spirit and intent, we're honoring our commitment to justice for Native Hawaiian beneficiaries of this program. Thank you.
Yeah, mahalo, Ashley. I hope, those are really practical and useful tips for beneficiaries and advocates alike. And it also underscores all the ways in which you can, proactively support self-determination, justice, and all those other important complementary goals and objectives of the Act by really respecting the jurisdiction of the commission and allowing Native Hawaiians to administer the Act in ways that align with their values, their experience, and their kuleana. As for my next guest, I imagine that when Prince Kuhio envisioned the possibility and the impact this Act might have on future generations, the story of my next staff attorney would fill him with pride. He's a fourth-generation Hawaiian homesteader who credits a multi-generational home he shared with his grandmother, a lessee, to providing the housing stability that his family needed. Henderson Huihui is an Equal Justice Works Fellow whose 2-year fellowship project is dedicated exclusively to serving DHHL beneficiaries, the community from which he came and that nurtured his success story, which is one example of the positive generational return on investing in the Hawaiian Homelands program in the manner that it was envisioned to serve. So without further ado, aloha, Henderson.
Mahalo, Summer, for that introduction, and aloha and mahalo, everyone, for the wonderful privilege and opportunity to speak to you all here today. My name is Henderson Huihui, and I am an Equal Justice Works Fellow and Staff Attorney here at the Native Hawaiian Legal Corporation. But more importantly, I'm a proud fourth-generation Hawaiian homesteader from the Waimanalo homestead. And so just as a bit of a background, I was born and raised on the homestead, and this is an experience that I will always be thankful for. And so my choice to pursue a career in Native Hawaiian rights, and really the impetus for my Equal Justice Works Fellowship, is that, like many other Native Hawaiian ohana, my family faced a lot of difficulty over the years. And having experienced the issues that many in our broader Native Hawaiian community face, such as financial hardship and other generational issues, I can speak to the stability that a homestead is able to provide in ohana for generations. Now, while a homestead provides families the ability to create economic stability, the homestead program does more than just that. When a family that experiences generational instability that many in our Hawaiian community face, having the stability of a home in a community of others who have that same experience, that same history and cultural heritage, it really provides you with the stability and not just having a home to live in, but also stability in knowing who you are as a Native Hawaiian. And that stability provides the opportunity to really be proud in your heritage and your culture, your identity. So because of this stability, I can confidently say, had it not been for our homestead, I do not believe that I would be in the position that I am in today speaking to you all here. Because I have seen both the potential for the program as well as its shortcomings, I was led to create this project in partnership with the Native Hawaiian Legal Corporation. Now, next slide, please. So the goal of my fellowship project is to empower beneficiaries of the Act through legal services and advocacy, provide education through the production of educational materials and pamphlets, and holding legal clinics to connect beneficiaries to legal and other services. And now the picture you see here is one of me and my family at our homestead with our then newly set up aquaponics system. I kind of just wanted to show that off real quick. But so a large portion of the calls that our office receives related to the homestead program is at its root, I would characterize as due to a misunderstanding or a general lack of education of how the program works, the rights and responsibilities of beneficiaries, as well as the responsibilities of the department, and really some of the sort of pitfalls that may come with homesteading. These misunderstandings range from simple issues such as whether the homestead lease may be passed down through a will, to the complexities of how a lease might be canceled and the effects of cancellation. Now, this general misunderstanding leads to sometimes larger and in some cases preventable issues, as beneficiaries are often left to navigate what can be complex administrative processes alone, and in some cases, sometimes favor the department. Now, the goal of this fellowship project is to provide beneficiaries with the information necessary to retain their homesteads for future generational stability. And so the issues that our office receives regarding the Hawaiian Homeland program are really quite broad and more complex than most would assume. And I think most would assume that the homestead program is just a land or housing program for Native Hawaiians, but really it's so much more than that, and it encompasses so much more than that. What you'll see on the next slide are some data points, which are sort of a breakdown of the Hawaiian Homelands related inquiries that I have been assigned to during the course of my fellowship. So from late September to about last week. Here we see issues related to blood quantum, environmental and access to water concerns, the wait list, and even internet reliability. Even within each category that you see listed here, the issues still vary widely. So for example, as we can see, the majority of the calls that we get concern successorship to either a homestead lease or the or waitlist application spot rights. Now with successorship, there's a number of issues that come up when a lessee passes away or when someone on the wait list passes away. In some instances, a lessee will pass away without having designated a successor with the department, and this leads to issues with their descendants. Or a lessee has named all of their children as the successor to the lease, and each has a different idea on what they want to do with the property. In some cases, it takes years for the designated successor to actually succeed to the lease, and this can lead to, all of these issues can lead to a host of bureaucratic nightmares for the lessee or the successors, such as liabilities, mortgages, and etc. Now, speaking of mortgages, there are issues that beneficiaries and their families, they must confront when it comes to mortgages for the homestead. For example, lessees and their families don't always know that because this is not sort of a regular fee simple property. This is a program and a lease designed for Native Hawaiians. Non-qualifying family members, that is those that don't meet the blood quantum requirements, they don't necessarily have the same rights to the homestead that they may have if the property were privately owned. Another consideration for this program, or the complexity of this program, is that homestead communities are more than just a suburb. They're really like a mini town that's been created. There are whole homestead areas that are essentially governed by an association. And these associations, they'll use their resources or the resources of the department to be able to create economic and other opportunities for their communities. Some homestead communities have within their homestead area natural resource management concerns, that they're confronted with or would like to address. Now, in sort of wrapping up this portion of the discussion, there are, of course, the larger overarching issues, such as whether the program is being adequately funded. Yet there are issues that everyday beneficiaries must face on their own in their own individual capacities. And so given the complexities and really the wide spectrum of issues, I believe that this demonstrates the real need for a dedicated approach to working towards ensuring the success of this program, so that more families have the stability that I was able to enjoy, and that their justice through the act may become accessible to them. And just as a quick aside, on this topic of homestead related issues, I just wanted to sort of quickly point out that, the homestead beneficiaries that contact our office, they also contact our office, with concerns that aren't directly related to the homestead program, but still impact or implicate their family's generational stability and their cultural identity. And with that, I'll return it to Summer. Mahalo.
Mahalo, Henderson. And Henderson just presented a whole bunch of information. And so I want to encourage anyone who has questions to go ahead and send them via the Q&A chat that appears at the bottom of your screen. If you start to send us your questions, we can start to field them before the Q&A session officially opens up. I just wanted to give you that little reminder and encouragement. Having heard the breadth and diversity of needs and opportunities arising from the Hawaiian Homelands program, let me introduce you to someone best equipped to share with you how legal and other advocacy by Native Hawaiian Legal Corporation, and hopefully you as well after listening to this webinar, can meaningfully impact access to justice for DHHL beneficiaries in need. David Kauila Kopper is the Director of Litigation, who started with NHLC right out of law school from UH Richardson, taking inquiries, answering our inquiry hotline, basically, and now litigates many of our complex and high-profile trial and appellate cases. But he's also equally committed to mentoring a new generation of advocates, because enduring impacts absolutely require a continuous pipeline of our best and brightest legal minds to keep advancing the cause of justice for as many as possible. So I'm happy to introduce the community to our litigation director, David Kauila Kopper.
Thank you, Summer. Hi, thank you everyone for joining us today. Like Summer says, I am David Kauila Kopper. I am the Director of Litigation here, and when I started in 2010 as a part-time intake staffer, I really quickly fell in love with our organization, our clients, our mission, and also with the attorneys who were there at the time and who all dedicate their careers to helping our community. And so it has been a real honor to follow in their footsteps and continue the work that our organization has done for the past 47 years. And for, again, the focus really is on our incredible clients and the work that they do. And our job as attorneys really is about service to them. For me personally at NHLC, I've worked on a variety of Native Hawaiian rights law issues that includes quiet title defense, historic sites and burial site protection. I've been involved and am involved in several cases regarding Mauna Kea. And also, my practice does involve quite frequently Department of Hawaiian Homelands disputes. If we could go to the next slide, I wanted to drill down on the idea of Hawaiian homelands and Hawaiian homesteads being critical to justice for Native Hawaiians. And I have here a quote by Chief Justice William S. Richardson, for whom the law school is named after. And he's articulating this idea about the fundamental importance of family land, Hawaiian family land, to Hawaiian well-being. Now, this case in which he was dissenting was involved a partition sale of Kuleana lands, of Hawaiian family lands. That is what he was talking about, but I really do think it is relevant for our discussion here, because one of Prince Kuhio's intent for the Hawaiian Homelands program was to provide families with lands for generational stability, like we heard from Henderson, and in part to make up for the lack of a true robust land base for Native Hawaiians, given that relatively few Hawaiian families actually receive Kuleana land awards during the Mahele land division. And again, these are the lands that Chief Justice Richardson was talking about. So considering that Prince Kuhio's intent was for Hawaiian homelands to serve as this land base, then I think if we replace his use of keeping ancestral lands with instead an idea of issuing and retaining homesteads and Hawaiian homelands leases, these words really highlight why these homesteads are so important. It is an interest that goes well beyond money. It's about establishing a family homestead, which guarantees, or at least I would say supports, the survival of that family. And it goes beyond money, goes even beyond land. It is a part of heritage and tradition. It really is a Hawaiian cultural issue. And so I think to say another way would be that Hawaiian Homelands provides eligible Hawaiians with a land base critical to both economic and cultural well-being. Now, given that fundamental importance, it shouldn't be shocking that there is a prevalence of Hawaiian Homelands related needs in the communities. There are issues that at least were raised today by Summer and Henderson and Ashley, and those really aren't theoretical. It is playing out in the community, and those can be larger macro level issues like sufficient funding for the department, the length of the wait list, concerns about DHHLs and the state's policies and practices. But there are also issues affecting the individual communities and lessees. And that could be adequate notice and education of lease requirements, lease cancellation issues, individual disputes with the department. And of course, there are needs that go beyond the type of legal services we provide, like needs for economic support. If we could go to the next slide, I wanted to use our statistics, our relative statistics about Native Hawaiian Legal Corporation's received requests for services to illustrate at least what we think are some of the current needs of the beneficiaries that we serve. So on any given day or week, Native Hawaiian Legal Corporation receives inquiry calls for services, and we keep track of that within certain periods of time, like a recording period, and keep track of the relative number of those inquiries. Over the last year since COVID, issues regarding Department of Hawaiian Homelands disputes and other Native Hawaiian land trust issues, which would include other government leasing programs, have made up at least 40% of the types of calls we receive. And that is up from our historical rate of about 25% of our calls. If we look at the other concerns, areas of concerns, which includes land title assistance, ahupua'a, kuleana rights, I think it highlights that, especially during COVID, land, housing, stability is a very pressing need for our community. And I think something else that is interesting, if we look at the other remaining categories, protection of cultural sites and preservation of traditional and customary practices, I think it highlights something that Prince Kuhio recognized, is that, and same with Chief Justice Richardson, which is the importance of cultural identity to Indigenous well-being, because one of the purposes of the Act is to promote economic self-sufficiency so that traditions, culture, and quality of life of Native Hawaiians can be forever self-sustaining. Now, if we go on to the next slide, again, just as a matter of example, these are our actual ongoing cases. So these are services that we provide, which go beyond brief services and counsel and advice. And we see the ratio is about the same. I think as a snapshot of the community needs, we could go over just real briefly the type of cases we have that are ongoing regarding the Hawaiian Homelands Trust. Those include, like Summer said, issues both big and small, those that affect communities as well as individual lessees. As a nonprofit service provider, the impact litigation that we have and continue to engage in really helps us maximize the reach and scope of our services, given that our resources are limited. So for example, we have our still ongoing Nelson lawsuit, which seeks to require the state to provide sufficient sums, sufficient funding to the department. Our Mauna Kea Access Road case, which addresses the practice of DHHL to permit the use of its lands for roads and highways without compensation to the department. Ashley recently was successful in a case helping an individual lessee on a lease dispute, but which confirmed the general rule that these leases are protected from judicial sale generally. And we have a current case on appeal about the department's duties to notify their lessees of pending lease cancellations. These are the broader issues, but NHLC does also represent Native Hawaiians and lessees on day-to-day issues. And for lessees in particular, we are involved in eviction defense and defending against lease cancellation. We assist with successorship issues, and we are one of the few law firms that take cases to amend birth certificates to establish genealogy and blood quantum for this purpose. And Ashley sort of previewed her work, which has led to the department creating rules to permit the use of DNA evidence to assist improving blood quantum. If we could go to the next slide, I wanted to address a common question, and that would be, why should those individuals who are not homesteaders, not beneficiaries, not applicants, care about the program? And looking again at this slide about the application wait list, there are 30,000 individuals approximately, slightly less, who are on the wait list as of 2020. And over 25,000 have residential applications that are pending. And we've heard from Henderson that these leases do provide generational stability. And I think that could be described in two ways, right? Generational stability in terms of, a lease can be passed on from generation to generation, but also that multiple family members, multiple generations can reside in a homestead lease at any given time. That is another form of generational stability. So if we look at that fact and also look at the fact that Native Hawaiians are overrepresented in Hawaii's houseless population, well, placing all waitlisted applicants in housing then opens up affordable housing for likely over 100,000 individuals across the state. That would be the net effect of giving true purpose, meaning, and intent and follow through to the Hawaiian Homes Commission Act. That is the reason that this is an issue of great concern. And I think we could just go to the next slide. You know, I want to highlight again some things. We've already talked about the importance of homesteading through generational stability and overall well-being. We know the intent of the program to actually issue leases. There's a trust duty on the state to issue these leases in a timely manner. But we know the wait list is growing, which must mean that these leases are not being issued at a rate that is sufficient. That means that, I mean, it has to be clear that Hawaiian Homelands beneficiaries are not being given the same support and attention by the state as other interests are. We know that the state has historically fought attempts and requests for adequate funding, even though that is constitutionally mandated. But at the same time, I think many of us can see what appears to be, I'll just say, our leaders, our legislature, bending over backwards to support other interests. While there was opposition within our legislature, there was a vote to authorize a long-term lease extensions of ceded lands. This is an example, to extend the leasing of those lands for over 100 years for commercial and resort and government use, even though that was contrary to public opinion. And I would say, prudent landlord decision-making, but yet that's still passed. We've seen special treatment for specific projects. And it's fair to say that Native Hawaiians and DHHL beneficiaries in particular are rarely, if never, the beneficiaries of the same extreme measures, even though the law clearly places a duty on the state to get Hawaiians on homestead leases in a prompt and efficient manner. So what kind of message does that send, right? In light of that duty, but also in light of the fact that the wait list has not sufficiently shrunk. At the very minimum, it's a message of systemic inequities, but prejudice cannot be removed from that. Because here, this program is, I think, a fantastic opportunity for meaningful change, right? We hear talk about the need for affordable housing in our housing crisis. We have a need for jobs and development. We see green light being given to large commercial development, to luxury development that really almost everyone on this call will never be the benefit of. And what amounts to what we see as lip service at times to Native Hawaiian interests, because this program could be the opportunity to create a lasting and shining legacy, not just for DHHL beneficiaries, but for everyone, right? We can build these homes on Hawaiian homelands, create jobs, create affordable housing, lasting generational stability. The state will start to meet its obligations towards Native Hawaiians, and we can really start to have the meaningful change that Prince Kuhio envisioned.
Mahalo for that. And I hope that our leaning into these difficult conversations is an invitation also for you to feel free to ask us some of these pressing questions that there's not typically forums where these ideas can be discussed really openly and thoughtfully and with real consideration. So just following up quickly, Kauila, on your portion of the panel where you noted that NHLC has seen an uptick in DHHL beneficiary requests historically from 25% to 40% during COVID for services that we provide. Any insight into, besides COVID, what accounts for that increase?
Let me unmute. So if we have seen an increase in the short term due to COVID, which I think has to implicate socioeconomic issues as being a driver of these issues or of conflict with the department, or at least of needs in the community, then the long-term increase of those same issues, I think it has to be at least related to the same drivers, meaning has there been meaningful change in the status of the condition of Native Hawaiians in the community? And just as time goes on and as the rate of lease issuance does not keep up with that need, that has to be one of those drivers and factors.
I'd like to add in on that. Now, if that's the case, one concern that I have is that, once these special COVID support programs, such as, the mortgage payment moratorium and things like that, or rent assistance and utility assistance payments, once those end, what's going to happen to beneficiaries now or then? I think there's, cause to believe that, given the slow economic recovery for families, especially those who are beneficiaries, I think, this may continue to have an effect on beneficiaries and may, there may be a rise in issues such as lease cancellations due to mortgage or default. Additionally, I think that the sufficient funding for the department and for the program plays a lot into this uptick. For a number of years, the department was not given the money that it was constitutionally afforded. I think that this had a direct effect on the length of the wait list. And however, funding doesn't just affect the wait list, though, it even affects beneficiaries who already have a lease. And so these failures, although maybe they are being addressed today, they still, because of the past failures, they have an effect on today and will probably continue on.
Okay, thank you. We've heard the panel really speak about or identify the challenges and like the problematic legacy of the program, but what about the opportunities beyond those suggested as a fix to Hawaii's chronic affordable housing crisis, which is one of the major ones, and absolutely there's opportunity to address that via this program. But are there any other avenues for addressing commonplace issues faced or complained of by DHHL beneficiaries?
I'll go first. I would like to see this as an opportunity for autonomy. And I know there was a question in the chat about self-determination. And if we're talking about a program and about sufficiency that will be forever self-sustaining, then that, which is the purpose and goal of the Act, then autonomy and self-determination has to be a part of that, because that is what makes something that is self-sustaining and ever-sustaining. I can see opportunities for more autonomy to beneficiaries, that they have a bigger say in who their leaders are. Because we often see that issue where if you have an administrative appointee to head that department, well, then there are going to be loyalties and duties and alignment of philosophies owed to that administration. But really the focus should be on the beneficiaries. They should be a part of the department. They should have a choice in their leaders and who is making those decisions.
And sort of to chime in too, I think a lot of the issues that we have heard today or talked about, a lot of these, or even the issues that beneficiaries call our office for, a lot of it comes down to a lack of education or a misunderstanding. And so, like, again, if we take the example of successorship, there's a lot of misunderstanding or lack of knowledge. And some of these issues, they're preventable had the lessee been, adequately informed of this information. And so with successorship, some of it can be prevented, if the lessee was informed that, there may be issues that will arise in the future if you name, all 4 or 6 of your children as a successor to the lease, that can create, family tensions. And so things like that, having a conversation or preventative education can really, I think, address some of these issues.
I also wanted to do a quick kind of jump off of something Kauila had said, and I think and Henderson touched on it a bit too, but when we talk about the autonomy, the department and the commission are advised by the state attorney general, which I think can sometimes present an inherent conflict because there can be priorities of the state that don't necessarily align with the department, even though there's this fiduciary duty, as we talked about, and there's a constitutional mandate to look out for the best interests of the beneficiaries. So I think a fix, an opportunity could be to allow the department and commission to more regularly have an independent counsel that can truly look out for the best interests of the trust, which would mean advising the trustees to look out for the best interests of the beneficiaries and maybe solve some of these issues that we're talking about. We do have cases that are ongoing with an AG that will represent multiple state agencies as well as the department and commission, and it just makes for, you can make one argument and you can't make inconsistent arguments. And I don't think that you can necessarily represent the interests of the trust that way. So that would be one of my suggestions.
Thank you, folks. Ashley, I'm going to direct this question to you. Can you explain the amended birth certificate service that we provide to be eligible for the Hawaiian Homelands program?
Yeah, sure. I know I brushed over it really quickly in the beginning and Kauila touched on it, but really what we're referring to is the amendment of a client's birth certificate to reflect the identity of the person's father for the purpose of showing the department or, whatever programs may require a birth certificate. It's a way of establishing your genealogy, and that's how you can show you're Hawaiian, right? Or that you have the requisite blood quantum for DHHL purposes. I think, we understand that oftentimes fathers get left off of a birth certificate there's a variety of reasons, personal and understandable. But at some point, someone needs to apply to Kamehameha schools or to DHHL, and then that puka ends up being a wrench in the application process, right? So you're not able to trace your mo'oku auhau back far enough to show that you're Hawaiian and how much Hawaiian you are. So when we first started working on these cases, we really relied heavily on the Department of Health rules and would submit to the department various types of evidence like testimony and DNA tests and that kind of thing. Still ended up in court just because it wasn't as easy as it should have been, I think. But after winning a couple of cases that way, the law ended up changing such that these amendments can only be done with a court order. So the process really isn't all that different. Evidentiary requirements are pretty much the same, but we go to court asking the court for a judicial determination of the client's father and a court order requiring the Department of Health to make the change. But the nice thing, as we mentioned, DHHL now has rules where you can use DNA to go, with your application straight to the department. And there's certain requirements for, those tests in terms of accreditation and things like that. So, and also I should point out the tests are not to prove that you're Hawaiian, but it's to prove your relationship to a person such that you can prove you are Hawaiian. So it's, there's more than one option, but I think a lot of people still want to amend their birth certificates because it's a record that you can keep in your family and it makes for easier time in the future.
Thank you for those additional details. Another question posed by an attendee, the blood quantum, 50% to 25% inheritance. Does it not set a time limit on the law in order to avoid US amendments 13th, 14th, and 15th violations? Also, basically, was the Hawaiian Homes Commission Act temporal or permanent? And if permanent, why the time and blood quantum limit? Kauila?
Yeah, I'll I want to add some mana'o to that. So we know from historic records that the 50% blood quantum was assisted upon by Congress and was intended to ensure that the program would sunset. And by the way, this is based on certain members of Congress and their personal intent. And they wanted the program to sunset so they could receive those lands back. And their thought, literally, was they believed that those individuals of 50% blood quantum would be bred out. In this, we're talking in this century. And I think it is an incredibly insidious requirement, or at least the purpose of it is. And I think we would all agree it is a very good thing that the predictions have not come to bear. What does the act say on its face when it comes to, is this a temporal or permanent issue? Well, I'll just, not to predict, the nature of success of legal challenges to the act, which I do believe is valid. It says that one of its purposes is to establish a permanent land base and to place Native Hawaiians on the land set aside under the act to assure long-term tenancy. And again, we're talking about generational stability. So, regardless of what some individual legislators may have intended at the time, I think we know through the good work of Prince Kuhio and the like that again, this was focused to bettering the conditions of Native Hawaiians. And I think even if we say so long as it is needed, we know based on the wait list, based on what we're seeing in our work, that even if this was intended to be a temporary measure, that it is still needed, that we are still in that situation where this program is needed and probably going to be needed for generations to come.
Thank you. Another question for everyone, whether, and actually maybe this one is best suited also for Henderson and Kauila in particular. The attendee is wondering whether with respect to the inquiries we receive and separately the issues we tend to assist on, do they usually serve leaseholders or applicants / non-lessee beneficiaries? What's your sensibility?
I can go ahead and answer. Oh.
Go ahead, Henderson. You beat me to it.
Oh, sorry. Well, maybe you can kind of chime in after or fill in any holes. So, though, at least with the inquiries that I have worked on, it's really both. Some callers will have issues for their leasehold. Some, they are a successor that was designated to a lease, so they're not technically a lessee yet, and they have concerns or issues arising under that lease, or even there's some that are on the wait list and have concerns maybe about the length of the time that they are on the wait list, or there's others that have called their office who are having difficulty even applying for the program. And as Ashley had mentioned, that's something that our office assists in helping those who have had difficulty improving their blood quantum for one reason or another navigate that.
I think that's correct. And if we look at NHLC's mission and purpose is to benefit Native Hawaiians as a whole, and our DHHL beneficiaries are a large part of that community. Of those beneficiaries, I think you can categorize, yes, lessees, but also applicants, or those that should be eligible to succeed or be applicants, or in some ways even benefit from the lease. And also to say, we're talking about lease specific issues and legal challenges, but there are also, I think, a common theme in other legal issues that are experienced by individual homestead beneficiaries that technically fall outside of DHHL related conflicts, whether it be issues of concerning traditional and customary practices, estate planning, taking care of kupuna, elder law. These are other issues affecting our community, which NHLC also handles.
Okay, I am going to throw this one out to anyone who's willing to answer. Can we talk about the use of Hawaiian homelands by non-Hawaiians? And I think we can incorporate in that discussion the uncompensated use of lands by the department to non-Hawaiian lessees. And so in that way, we can tackle both the question posed as well as an ongoing issue of, great community importance and public interest.
Don't everyone jump up at once. I will start with maybe a more ancillary issue, which also relates to another question that I see we've received. And this is going to be concerning the use of Hawaiian homelands trust lands by other government entities, which I think qualify as non-Hawaiians, and it's appropriate because right now the picture up on the slide is of the Mauna Kea access road is seen from Hulu. And that I think is unfortunately just one instance, but yet a prime example of what we are talking about. So if you can see this road, which is preceding Mauka, that is part of the Mauna Kea access road, that is trust lands, Hawaiian homelands trust lands. That road was bulldozed and created initially, I believe, in the 60s, continues to today. It has been designated now as a state highway recently, and no compensation was ever paid to the department for the use of not just this road, but many other roads across the state. That is something of real concern because, the department, at least in an ongoing lawsuit that we have about this road, has joined in with the state to say, hey, no compensation is needed. Well, knowing that the wait list is still what it is, knowing that there's a need for sufficient funds. This is just one instance of how the use of trust lands by non-beneficiaries are impacting the trust.
And to kind of add to that, the leasing of trust land to non-Native Hawaiians, I think you kind of have to ask the question, why is that being done? Historically, the department has been, and the program overall has been severely underfunded. And so the department needed to basically raise its own funds to support itself, to keep the lights on. And so it started to lease out lands for commercial and other purposes to non-Native Hawaiians to be able to keep the lights on. And that's actually something that the Supreme Court had noted in our Nelson case, that it was the Department of Hawaiian Homelands was one of 17 executive departments that was sort of tasked with providing its own funding. So I think the department would not need to enter into these leases with non-Native Hawaiian persons or entities if they were sufficiently funded as the Constitution provides that they should be.
Okay, thank you. I can take one of the other questions posed by an attendee. Are NHL's legal services free? So we're a nonprofit, and although as a nonprofit, we are here to serve the public. Our funding isn't guaranteed. Every 2 years, we compete for a professional services contract through the Office of Hawaiian Affairs, and as you can imagine, our roster of people we help, 400 folks a year, is really dependent on how competitive we can be. And so while we are committed to providing free services to indigent people so that nobody in need of legal services will ever be turned away for reasons of economic inability, we do charge for services for those who are not income eligible for the fee waiver, and do so at a much subsidized rate that is way under what the private market charges, and that's in part because of the funding we receive from the Office of Hawaiian Affairs. They're able to subsidize our work and our efforts in order to keep serving communities as we have been for the last 47 years. So I hope that answers that question. Let's see, I'll look for another question.
No, I'll just take you know, I want to reciprocate a mahalo from Uncle Wade Lee. Good to hear from you, Uncle, and mahalo back at you for standing for beneficiary rights as well. I think that's a good point. Is there's been so many battles fought and a lot of knowledge out there. I also see Alan Murakami, a former attorney at our office, long time there, and I think you're right. There is a need for some sort of database or a way to preserve that collected knowledge. I think that's a fantastic. I saw some questions about out of box ideas. I don't know that that's so much out of the box, except maybe just something that's necessary. So mahalo for that.
Okay, I'm gonna read a question verbatim from one of our attendees. Mahalo for the important explanation about the role that successorship can play in supporting generational housing and other needs, coupled with the ability to pass homes to successors and then go back on the list. Is there an unintended impact that families with capacity are able to secure multiple leases at the expense of those ohana still waiting for one? Appreciate that if DHHL was adequately funded, we wouldn't have to sort of pick between these beneficiary groups, but any mana'o on that procedural practice?
That is a really poignant and I think fair question. And I think the attendee really identified what could be the cause of that, right? If DHHL was adequately funded, if there could be available homes for everyone on the wait list, that would not be an issue. I think one point of clarification, it is true that once you receive a homestead lease, that individual is not eligible to essentially receive another one as an award. And I believe unless everyone else on the wait list were offered, though you are correct that when they sort of get back on the lease, they can make a purchase from another lessee. And that is a concern that could be part of what is the inventory that should go to beneficiaries. It is now with those who do have means, and that does make sense of a concern. But also, I think it's almost a catch-22 in that we also want beneficiary autonomy over their leases, correct? So, how is that balanced? And I think like you pointed out, instead of the conflict being between beneficiaries, right? It's instead the duty of the state and the department to provide that adequate inventory. And that would, if that trust duty was satisfied, it would remove any of that conflict.
Okay, I really appreciate the next question because I think it speaks to the idea that people in the public want to know how they too can sort of help current and prospective beneficiaries better. The question is, how can public schools participate to increase education for potential or current beneficiaries? I think it speaks to the program Henderson Huihui is implementing via his fellowship project and some of the needs and concerns he's been able to identify from the Homestead community and also from our own legal advocacy experience, where increased education could really do quite a bit to help the community. So Henderson, you want to take that one? How can public schools participate to increase education for potential or current beneficiaries?
I think that, that's a really great question, and I very much appreciate it because, I think there needs to be some sort of conversation that's facilitated, by the state, whether it be through DHHL or even in partnership with the school system. And it would provide a forum for those who have knowledge on the whole program, its administrative processes, how to be successful in the homesteading program, how to retain your lease for generational stability. I think it would be fantastic if some sort of program were created in partnership with the school system to really have that conversation. But I think it would be more appropriate sort of as a family sort of program, that it wouldn't necessarily be targeted towards school children or anything like that, but to really the whole family, so that as an ohana, as a unit, they can embrace their homestead, they can come together, learn what needs to be learned, and go forward as a family. I really like that idea.
Thank you. Okay, Kauila, did you want to add to that? I see you're mute. Nope. Okay.
Oh,
You're accidentally unmuted. Or so, okay. I think I'm gonna throw this question out to everyone because in part I think it speaks to our ongoing Nelson litigation and sort of what inroads we're making with respect to this concern. Do you think a cognizable claim could be made against legislatures, and I'll just say like the state of Hawaii, for malfeasance, for advocating against or failing to uphold their constitutional duty to appropriately fund the homesteading program?
I can add to that. So, unfortunately, the legacy of the Hawaiian Homes Commission Act is a legacy of underfunding, not enough, a lack of funding to accomplish its trust purposes. And so our office has, sought to address these concerns, this funding issue with the department under a case Nelson versus Hawaiian Homes Commission, and that names, the commission as well as the state as defendants in this. Now, in Nelson, the plaintiffs, our clients had, argued that the state failed to provide the Department of Hawaiian Homelands with adequate funding, and that the department breached its duty to seek these funds. Now, the plaintiffs in the case, they argued that under the state constitution, the state is obligated to sufficiently fund DHHL. And now this Nelson case, it went up to the Supreme Court, and there was one question that the court had looked at, and that's, was there anything to show what sufficient sums under the Hawaii State Constitution means? Now, under Article 12, Section 1 of the Constitution, it states that the legislature shall make sufficient sums available for the following purposes, and it gives four purposes in which the department should be sufficiently funded. Now, the court, what they did was they looked at the Constitutional Convention of 1978, or the CON-CON, to see what the delegates at that time, when that sufficient sums language was adopted, what they were thinking. And so at the time, the committee reports had shown that there was concern that the department needed sufficient sums, that they didn't have enough to do what they were supposed to be doing. And so one of the conversations that the delegates had was that the department would need for administrative costs $1.3 to $1.6 million. That's just for operating admin costs. And as I had mentioned, prior to this constitutional convention, the court had stated the committee considered it especially problematic that DHHL was the only one of 17 executive departments forced to finance itself by leasing its own land. And if you think about that, it's kind of mind-boggling that an executive department within the state government, not only that's really charged with the execution of this trust program that was a compact of statehood, that they needed to fund themselves by leasing and raising their own money. And so later in this Nelson case, what came out to is that, the department, or rather the courts have determined, that the sufficient sums was $1.3 to $1.6 million at a 1978 and adjusted for inflation. And so after these Nelson cases, the department had received, additional funding, and maybe they're still, it can be argued whether or not they're receiving what they actually need. But since this litigation brought by our office and our plaintiffs or our clients, the department funding has increased.
Okay, great. Thank you, Henderson. I am going to ask this really appropriate question too. What should non-Native Hawaiians do, or what can they do to support Native Hawaiians? So many Japanese in positions of influence in politics, education. I think that can be said for other groups as well. But yeah, how can a non-Native Hawaiian really be a champion for the kind of purpose and goal setting that the Act was intended to achieve and satisfy?
I'll start. I think that support needs to be meaningful. And first of all, this forum is an example of that sort of meaningful support, right? Is sharing your platforms, sharing your connections, sharing your networks to advocates, to beneficiaries in a meaningful way. And this is just a start. And we've had fantastic attendance and support and questions. This is just one small example, but that sort of support needs to be meaningful, right? Not just limited to education, but having important Native Hawaiian leaders and voices in critical positions of authority, of power, who can use their experience and their advocacy on behalf of Native Hawaiians to make meaningful change. And that's hard to do. We can recognize that. To relinquish those positions, to hand over those networks, but that's the only way that we can have change, because we've been doing it in this matter for 100 years. We know what works and what does not. And I think there is a want for meaningful change. So I appreciate that offer and what seems to be a real intent of support. And I think those are some of the ways that support can be meaningful.
I agree. And, I'll just also add that, and it goes to the point of relinquishing some control and making, really a concerted space for Native Hawaiians to fill positions on commissions and boards and different organizational leadership opportunities. And all of that really goes to what is a really uncomfortable thing, which is disrupting the status quo, right? We know that at the inception of the Act, the idea even that a program that would disrupt the status quo blunted its impact by making sure that most of the lands allocated to this program would be essentially unusable. It would be the kind of land that nobody wanted anyway. And we cannot imagine a better program, a better outcome for Native Hawaiians if we don't really use our voices, use our networks and our powers of influence to feel okay about status quo changes, because that is, again, the only way, I think, to get this done. And it will absolutely require the support of the non-Native Hawaiian community, because our numbers don't allow us to have a lot of authority and or exercise the kind of voice and influence that we'd like to. So thank you for that question. It is a thoughtful one and one that we definitely need to champion more. I think we're kind of coming to the end of our hour or hour and a half here. And one question from an attendee actually also speaks to how achieving or fulfilling the goal and the purpose of the act can actually come to bear. The question specifically is, I'd like to know what each panelist, and we'll go through each panelist, thinks is the most novel, big picture, out of the box, kind of game-changing idea that they have or know of that would dramatically change the course and finally transcend or make right the past century of injustice, both at the federal and state government levels, with respect to this program. How can we really achieve true purpose and the fulfillment of Prince Kuhio's vision? I'm gonna throw that out to each of you to help close out this discussion. And before I do that, I also want to thank everyone so much for giving so much aloha to our organization and to the speakers in particular, who are really the frontline advocates and champions and who I am proud to work alongside. So I appreciate you giving us the time to introduce them to the community. Mahalo.
I just kind of wanted to, say that one thing that I think of or see, I've often seen, a call for the department to kind of be creative in solving their waitlist problem and creative in solving all of these problems, but really I don't think there is a creative solution. The solution is clear, and that's, that the department be sufficiently funded, that they're able to have enough money to do what the vision and purpose of the act is.
I was just gonna throw out there that I don't necessarily think yes, there probably are out of the box ways of thinking about this, but I think throughout the course of this whole discussion, there's been a lot of ideas, and they're not necessarily out of the box. They're really just living up to what the program was intended by doing all the things that need to be done, just like Henderson just said. So yeah, I think there's room for change just with simple solutions.
I definitely want to see more beneficiary autonomy, or at least allowance for their participation in the governance of the department and this program. It's not out of the box. I think a small micro model for that is the Kuleana Homestead Program, where Hawaiians have more flexibility. Beneficiaries would in theory have more flexibility, autonomy in creating infrastructure, self-determination as to how to use those trust lands. I'm not sure that sort of idea has been given full support, or at least been explored fully. And I think that just, again, that idea being autonomy, self-determination when it comes to the success of the program.
Thank you, everyone. I think we've come to the close of our hour. I want to also invite everyone to, if the work that we do interests you, please visit our website, Native Hawaiian Legal Corp.org, or follow us on Facebook and Instagram. We're trying to up our social platform game a little bit on our nonprofit budget. It's a little bit hard, but we've brought on a really talented person who I actually want to take the opportunity to thank right now, Sheldon Obrey. He's working behind the scenes, even getting this workshop and webinar together, and we're growing our ohana. So we thank you, and we wouldn't be able to do what we do unless the community supported us, and the clients who were in need came to us and provided us the inspiration and the meaning and the purpose that we need to do the work that we do. So everyone on this workshop and webinar, mahalo so much. We look forward to our paths crossing again. And until then, you guys take care, be safe, and ma'alama pono. Aloha.